Hi, good afternoon, everyone. I hope you can all hear me. Thank you so much for joining us today. Hopefully, at least some of you from your gardens, given how beautiful it is outside. By way of introduction, I am Elizabeth Doherty. I'm a partner in the private clients dispute team at Macfarlane's in London, alongside my co-chair, Jonathan R.
Hi, everyone.
Jonathan and I are not family lawyers, but as contentious trust lawyers, we're accustomed to advising trustees and their beneficiaries in the context of a divorce. So the jumping off point for today's webinar is an article that Jonathan and I wrote with the help of some of our colleagues at Macfarlane's for the High Net Worth Divorce magazine, which we entitled Trustees and Divorce, Navigating Stormy Waters. No doubt we'll be stretching that analogy to the point of divorce today, so please do bear with us. Although the opening words of that article were debt, death, and divorce, it focused, hopefully a little bit more positively, on the questions and strategies that a trustee may consider when faced with the divorce of a beneficiary or beneficiaries. And in particular, how, if at all, trustees may choose or be forced to wade into that dispute. But this is clearly not an issue that only concerns contentious trust lawyers, but family lawyers and trustees themselves. So with that in mind, we thought it might be a good idea to gather together some of our friends from across the professional divorce spectrum, if that's an acceptable phrase, to give their own perspectives on the particular challenges and stumbling blocks of a high net worth divorce where significant wealth is held in a trust structure. And also to consider how, practically speaking, parties might position themselves in the calm before the storm, or where waters are getting a little choppy, so that the storm may be weathered or even navigated around. I did warn you I was going to do that. So with that, I have the pleasure of introducing our panel today. Welcome to Alex Carruthers and Mark Harper, who are both partners at Hughes Fowler Carruthers, specialising in high net worth, international divorce, and in particular divorces involving trusts. We're also very lucky to be joined by Clare Usher Wilson, who's Deputy Managing Director at Summit Trust International based in Geneva. She has a wealth of experience in managing complex trust structures, including where beneficiaries of such structures are getting divorced. She's also in the rather enviable position today, because she's in Geneva, of joining us from a real-life boardroom rather than a home office. To provide our Chancery perspective today, we have Bajul, Shah and Alina Gerasimenko of 24 Old Buildings. They are both barristers with a broad Chancery practice, including in trust disputes and in particular those with an offshore dimension. We may also have an additional rogue panel member from time to time in the form of my children, for which my apologies in advance. They have a sixth sense for video calls, so it's almost inevitable they will try and chip in at some point. And unless I lock myself in the bathroom, which I really did seriously consider, there is nowhere for me to hide. So our proposal is that we give each of our panel members a few minutes to speak about trusts in divorce from their own perspectives, and then move on to a panel session where we try and focus in on the practical things that trustees and families can do to try and prepare for the storm that may be caused by a divorce. We will obviously try and leave time for lots of questions at the end. So with that, I will hand over to Alex and Mark.
Thanks very much. I think the most common way of attacking trusts on divorce is to allege that the assets in the trust are a resource available to one of the spouses. That's part of the court having to categorize assets and quantify them at the trial, and then deciding how those assets should be divided. And if a trust asset is a resource available to one of the spouses, then it falls to be divided And if it's a marital asset, then it would usually be divided equally. So the test as to when a trust asset is a resource is still set out in my case of Charman, a Court of Appeal decision. And the so-called Charman question is, if the trustees were asked to distribute all or part of the trust capital to the beneficiary in question, would they do so? And if you're acting for the attacking spouse, then you hope that the trustees are going to be partisan and they are going to come up with some nonsense that doesn't fit with what the documents say. Quite often, you can read in the law reports, there are cases where the letter of wishes says, as in Charman, please treat me as the principal beneficiary with the fullest possible access to the trust income and capital. But then the trustees say we wouldn't distribute a penny to this husband if he asked for the money. So how the Charman question is answered is really key. And in a more recent case called Dagger and Banger, that was one where the wife's father had provided the money for the trust, and her letter of wishes said, please consider my father's views if you're asked to exercise any powers to distribute assets. And the father gave evidence at trial and made it quite clear that he hated his son-in-law, and he didn't want him to get a penny of the money in the trust. And the judge thought that that was quite understandable. And so all $20 million or so of the money in the trust was regarded not as a resource available. So that's an example of how fact-specific it is. In another more recent case where I acted, the question was, the husband was a life tenant of a trust worth £100 million, and his net income a year from the trust was 1.2 million. And the wife wanted a big lump sum from the husband on the basis that, of course, the trustees would distribute some of the capital. But the judge accepted that because the husband couldn't be trusted with money, that the trustees would never distribute capital to him. And this was a case where I was instructed by the official solicitor because the judge had held that the husband lacked capacity to litigate. So those are examples of what the resource test can be. Now, Alex, over to you on variation.
Thank you, Mark. So resources is one option available, but the nuclear option for an attacking spouse is to persuade the court, the English divorce court, to vary a trust. This is something that causes trustees and Chancery lawyers a great deal of angst. It is set out in section 24(1)(c) of the Matrimonial Causes Act, which states the court may make an order varying for the benefit of the parties of the marriage and of the children of the family, or either of them or any of them, any antenuptial or postnuptial settlement made by the parties to the marriage. It's a very wide power. It can destroy trust, take money out, give it to other parties, set up bare trusts. And so it is something that if used, can be extremely effective. When considering whether, as an attacking spouse, you are going to ask the court to do it, I think there are three steps in the analysis of the power. The first is whether the trust which you are seeking to attack is nuptial or not. Now, the definition of nuptiality is something that's been looked into over many years. It's generally thought that the court is going to ascribe a very wide meaning to it, and it's going to cover any trust that gives provision to one or other of the party to the marriage, a provision to either of them during the marriage. But it has to be a particular marriage. It can't just be a prospective one long time in the future. It's very wide in that the trust doesn't have to be set up by either of the parties. It can be a foreign trust, and the trustees don't have to be in this country. Those are issues that we will be discussing later in this webinar. The second step I would suggest is, if it is a nuptial settlement, to look at what is actually the property within the trust that is nuptial. There are two issues in this respect that I would suggest. The first is, quite often the property is actually real estate. And in that circumstance, you have to consider whether the nuptial element is the beneficial ownership of that property or a right to occupy. If it's the former, then as an attacking spouse, you all well and good, you can take the asset out under the variation powers. But if it's just a right to occupy, then you're just going to be able to vary that right. The second issue in this, what is the type of property, is something which is going to be discussed in more detail by Bajul, which is DR and GR, that actually you've got to analyse, does the trust, is its ownership shares in a company, or can you construe it to be ownership in the underlying assets if there is an in-between company? The third thing when analysing the power, I would suggest, is that how the court will exercise its powers if it is a nuptial settlement where there is a substantive asset that is property to it. Now, the leading case in this is Ben Hashim, where Mr. Justice Mumby, as he was then, set out a very detailed, as he always was wont to do, test for how to look at these assets and how the court should deal with them. And he set out the balance of fairness between the attacking spouse and the other interested parties, including beneficiaries and creditors. And he made it very clear that you just don't take the money out. You've got to balance everyone's views before making a final decision. But then that's not the end of it, because even if you have a power and the court decides it should exercise it, can you get cash? Because that's what our clients want. That comes to enforcement. And here I think that you should really start at the end when analysing an attack on a trust. You've got to look, are you going to be able to enforce any order? We've been making the family division these orders for decades, and offshore jurisdictions which have been attacked have become rather wary of us and have developed firewall jurisdictions. There is a lot of puffing their chest out about how these are going to prevent attacks by our orders. There haven't been many. I think there's probably been one Cayman Island attack that's been set off. But it is a real issue for us, because certainly in the last few years, the English divorce court have acknowledged that there are problems and have refused to make orders in at least two cases because of prospective firewall difficulties. And so what I mean most, you've got to start at the end, is you've got to go and look, where is the money based? Where is the trustee? Where is the trust? Am I going to be able to persuade a judge that I can to vary all these things? You're going to need foreign advice along the way if you've got problems on that. So that's just a whistle-stop tour of variations. We're going to talk a lot more detail about it now, but obviously that's very dry law, and actually we're dealing with people, and one of the most important persons that we're going to deal with is the trustee. So I'm going to pass over to Clare, who's going to deal with trustee issues and how she sees it from her view.
Thank you, Alex. And I'm not Clare, obviously, as you've gathered, but I was just going to say a couple of words about questions, because I know we've had some coming in before Clare starts. And I think if we've been asked to make it clear that if you could at all possible use the Q&A function to ask questions, and then as hosts we'll do our absolute best to moderate those and try and answer as many as we can, or get the panel to answer as many questions as they can before we get to the end. Can't promise we'll be able to do it for everyone, but we'll try our best. But as Alex said, this issue is one where it's easy to get caught up in the intricacies of the law, but the trustees on the ground have to deal with the people concerned first and foremost. And so it's with great pleasure that I hand over to Clare from Clare from Summit. He's going to take us through some of the things that she has to think about when a divorce strikes a family who she's helping out. Clare, over to you.
Thank you, Jonathan. I think right now I'm feeling pretty sort of authentic as a trustee, in a way that, divorce is coming my way and I feel a little bit rabbit startled in the headlights, or maybe today it will be rabbit startled in the light of my own phone. But anyway, clearly for trustees, this is not a moment to lose our heads. And you don't know what's going to be coming down the road as these cases evolve. But I think, your starting point is that all your decisions are going to be framed with the principal trustee duties in mind. For me, the three big ones, maybe there's more, but 3 is easy to count to, would be the duty to obey the directions of the settlement. That's to say, the trustee can't do more than the terms of the trust set out, or that the terms that the law permits, except where direction is otherwise given by a supervisory court. The second one, the big one, is the duty to act in the best interests of the beneficiaries as a whole. And the third one is, of course, to preserve and manage the trust property. So those are the duties that are going to be sort of framing our decisions as they arrive at our door. I think at the outset, we will be thinking about things like, how to respond to requests of information, dealing with variations, questions of joinder of the trustees to the proceedings, and of course, the submission to the foreign jurisdiction. I'm going to actually shamelessly swerve the last 3. Yes, it can happen, but I think our expectations at the outset would be that the court would only be using the variation powers to the minimum extent to obtain justice, basically. Joinder questions would be related to that. And as for submission to, in this context, the English court, I think 15 years on, I still have the Minuela court case, Jersey court, well, frankly, ticking off, ringing in my ears. I mean, they said, to the extent that having submitted to the jurisdiction, they failed to protect the position of the beneficiaries, it is possible that they may be liable for breach of trust. So yeah, that I don't want coming in my direction. And the others all feel very complicated and very expensive. And actually, I think it's probably quite difficult to reconcile those 3 trustee duties with them. So I am going to focus exclusively in this on careful disclosure of information. Now, at the outset, but I think it's just been confirmed by Mark, it's my expectation that the family court will assume that the trust is a resource of one of the parties, especially if it's a settler interested trust. So disengaged trustees that let the court take the inference that the interest in the trust is actually greater than it is, surely cannot be acting in the wider interests of the beneficiaries. So I think some sufficient information to set the record straight will be needed. So what sort of information are we talking about here? Cases I've been involved with, the list normally goes something like this: copies of trust deeds, copies of financial statements, trusts and underlying companies, schedule of assets, supplementary instruments, letter of wishes, distribution schedules, very detailed ones, dates of request, identity of requesting party, reasons for it, copies of the actual request, copies of the actual response from the trustees, amount provided, and if any have been refused, the reasons for the refusal. So, I mean, at this point, you're really sort of in the inner sanctum of the trustees' files. These are things that are not generally shared. There may be some squeamishness in sharing it, and there may be some squirming if the files don't read well. Words like client and the like, you want to be steering clear of that. But let us take this, that the trustees have got to a comfortable position that sharing all or most of this information will be in the interests of the beneficiaries and will help preserve the assets of the trust. I think the first thing before you start winging these things out is the actual confidentiality legislation of the trust law. Give that some careful thought. an interpretation, for example, of Cayman is that to disclose information requires the express or implied consent of the settlor or the order of the court. So maybe in this case, getting the consent of the settlor might be tricky. But I think that's a theme that you want to be working on, because the next element is then one of trustee neutrality. I don't think we're opening up any trade secrets if we say that in non-contentious trust situations, oftentimes the trustees will be communicating much more regularly with one senior beneficiary, and not all the adult beneficiaries equally. This is done not out of a particular desire to conceal the existence of the trust. It's much more, normally the family and close family interests are aligned with the natural financial provider of the trust. However, it's probably going to be a difficult conversation, or at least an unexpected conversation, to the principal beneficiary contact to learn that all the information that goes to them will go to their soon-to-be ex-spouse, and possibly their children if they're represented, as they may well be. But this is a conversation that needs to be had, and I think an information, addressing the information unbalance is probably a good place to start. I think you could also do that with sending the recipients a slight reminder that the information is confidential and shouldn't be used for collateral purposes. So, are we ready to go yet? Well, normally the trustees would also be looking for some sort of court blessing in these situations. So, all of what I've said, the trustees wouldn't normally be winging it. This would all be quite well advised, but I think at the end of the day, they would like normally a court blessing about their decided, path of action. There's quite often a practical obstacle, which is that the two proceedings go at very different speeds, and that will be something that the trustees will have to grapple with. Beneficiaries need the information; their court hasn't yet sat to decide on the question. So, just to sum up on this, getting back to the original reasons why you're thinking of disclosing this information, being effectively to give the court, the family court, a realistic profile of the trust, to let them make a realistic assessment of how likely a distribution would be to help fund a settlement, whether both the divorcing spouses will remain beneficiaries afterwards, something else. Possibly to remind the family court to keep the other beneficiaries' interests in mind, and and protect them, particularly if they're minors. So I think my sort of outset would be that constructive communication in these instances would be the best way forward.
Thank you so much, Claire. I think we're really starting to get a flavour from what's been said so far by our speakers of the complex considerations a trustee may well be grappling with in a divorce. But just in case anyone needed any more convincing, I'm going to ask Bajul and Alina to jump in now and talk a little bit about some of the really knotty issues that may arise where particularly complicated structures are involved, or where questions of, as we've alluded to before, privilege or joinder raise their ugly heads.
Thanks very much, Elizabeth. Yes, the complexities become even more magnified when you have the sort of trust structures that we're so used to seeing nowadays with high net worth individuals. You'll have the trustees at the top owning often shares in a number of offshore companies that often act as holding companies. Underneath them will be a network of other companies, and then underneath the whole structure will be the actual underlying assets, often property in the UK, possibly trading businesses. And that complex structure throws up a plethora of difficult issues. We want to touch on some of them in the course of the next few minutes, focusing on the following points. Looking at what aspect of the structure should be regarded as neutral, issues to do with the joinder of the correct parties, how any underlying financing in the structures might affect any award, and a couple of practical points to do with costs and common interest privilege. I'm going to hand over to my colleague Alina, who's going to first talk about nuptiality in this context.
Yes, thanks, Bajul. So if we're into the territory of variation of nuptial settlements, one of the first things that need to be considered is what part, if any, of the structure may be attacked as a nuptial settlement. Is it the structure as a whole, or is it the trust, or is it one or more of the underlying companies? Now, DR and GR confirmed that a company which made some form of continuing provision, one or both spouses, was capable of itself of amounting to a variable nuptial settlement, whether or not the company is owned by a trust of which the spouses are formal beneficiaries. Jane on to say that if some form of continuing provision for both or either of the parties to a marriage has been made, which would include on the authorities the provision of accommodation from assets held by a group of family companies, then the entire setup, when viewed as a whole, is capable of amounting to a variable nuptial settlement. So from that we can see that we could be attacking the whole, or we could be attacking one company if that is the one that is making the provision for the spouses. It's also necessary to consider whether the settlement is one of use or of ownership. So in the case with underlying property particularly, in Chai and Peng, for example, a large country estate in Hertfordshire, the Rossway estate, was held by two companies, Central Point and Dunross. So it's more in that second category that Mostyn was discussing in DR and GR. Dr. Peng and his family lived in the main house, with the rest of the estate being run commercially by renting out land and cottages by Central Point. The court found that the companies held the estate on resulting trust for the husband, and so it was capable of being transferred to the wife as part of her overall award. So the question about variation didn't specifically arise, but Obiter, Mr. Justice Bodie, stated that if there was no resulting trust, the Rossway estate arrangement was all set up to be a continuing provision for the couple and their family, the house to provide accommodation, and the estate to provide a pleasant amenity and income. However, he noted that realistically any settlement was as to the use, not as to the ownership of the main house and the estate, which meant that since Central Point and Dunross, the two companies, were the owners of the property, assuming he was wrong about his resulting trust analysis, it would not be right to vary the trust in such a way as to wholly deprive them of their property. That outcome, he said, would be disproportionate and would pay insufficient regard to the decision impressed. However, he did say that a fair and reasonable result might be to vary and extend the license given to the wife notionally, but not actually by the company by the husband, to use the main house such that the license would pertain for her life without payment. He went also the wife's variation application as regards income provision from Central Point's part of the estate to await whether the husband complied with the lump sum order and other orders he proposed to make, so that that application could be restored if he didn't comply. So if what has been settled is the use, the court might vary that settlement to provide a license to occupy, and the question's been left open also to potentially provide income. However, that does raise some questions of practicality. For example, recently involved in a case where for the wife, one of the key aims was to obtain the holiday home in Italy. That was owned by a company, which was in turn held by a dynastic trust. Now, following DR and GR, it was certainly open to the wife to call for the variation of the company as a settlement which made some form of continuing provision for her and her ex-husband. But there was a real risk that the court would find it was only a settlement of the use rather than the ownership of that property. And it was clear that in the particular circumstances, a license to occupy for the wife in certain summer months, for example, would have been entirely unworkable given the level of conflict between the parties. So it is important to consider what the settlement is of in order to consider the potential remedies and whether those are realistic in practice. Now, Bajul will consider the question of joinder, because that is another very relevant consideration where we do have this complex structure.
Thank you, Alina. So as regards joinder, I think there are two things to be thinking about from the point of view of the trustee. First, who is likely to be joined within your structure? And if, for example, the attacking spouse is looking at the companies as possible nuptial settlements, then there is a very real chance that it'll be the companies and the underlying entities that may well be joined as well. There is an interesting question as to at what stage the entities may be joined. The judicial attitudes in England seem to be shifting on this. In DR and GR, Mr. Justice Mostyn took the view that it wasn't necessary to join the trustees. You simply needed to notify them. But in TM and AH, Mr. Justice Moore was very much of the view that you should join the trustees as part of their Article 6 rights. In fact, in the course of argument, he said, of the 17 judges in the family division, I can tell you that there is only one who thinks DR and GR is correct. But it is a point to bear in mind when considering whether you're at risk of joinder. The other question on joinder is this. Trustees can seek guidance from the court as to whether they should participate in the proceedings or not. But companies can't, because there isn't a supervisory jurisdiction of the companies. And therefore, trustees have to think very carefully about what stance the companies ought to take to the extent that they have any control over the companies. And whether, for example, as part of their own directions hearing in their home court, whether they can ask for directions in respect of their assets or the affairs of the trust, and that includes the companies as well. A difficult area, not well trodden, but it's certainly worth thinking about. Time is slipping away, so I'm going to pass over to Alina to talk briefly about issues to do with underlying financing and how that affects orders.
Yes, so again, another matter that needs to be given some consideration is finance, namely how the underlying assets have been paid for, whether that's by commercial loans or by using trust assets or family wealth, and how that might affect the court's remedies. The complexity really arises depending on where the financing or external borrowing is in the structures and the kind of variation that's being sought. And that appears to have been recognised also in Chai Peng by Mr. Justice Bodie, where when he adjourned the wife's application to vary the settlement to provide income, because he said that at that point he was insufficiently informed about the relevant company, Central Point, and the commercial arrangements underlying that to know what impact there might be, for example, on creditors of such a variation. And other practical problems are going to be addressed by Bajul, now again running out of time slightly.
So two very short points to think about: costs and common interest privilege. Trustees often think that they share common interest privilege with the settlor or the husband in particular who's getting divorced. Be careful. Look and consider carefully whether the interest of the trustees in the litigation is properly aligned with the interest of the husband, so as to have conversations with them on a common interest privilege basis. Because if you wrongly take common interest privilege in these matters, then the reality is that the discussions may well be disclosable and privilege will not protect them. Costs, a couple of points to think about. In the trust structures that we are used to seeing, the trustee is not often cash rich. The cash in the structure is often at a different part of the structure. So first question, how is the trustee going to get their hands on the cash to be able to fund the litigation? Second question, often an issue in dynastic trusts, how does the trustee allocate that expenditure? Should you allocate it against the overall income of the trust, or should you allocate it notionally against the share that, for example, that particular beneficiary or that particular pot will bear? Difficult questions, often worth raising them in a better application. I think that's all I've got time to say. I think we're now going to move into a panel session.
That's right. Thank you, Bajul. Thank you, Alina. That was really helpful. Look at some of the difficult issues which arise for trustees and what they and the things that they have to think about. We, as Bajul says, the next step in the session today is to move on to a panel discussion, because we've had a lot of very helpful setting the scene from all of our speakers, explaining how they look at things from their own particular perspectives, and how and what the issues are that people are grappling with legally. We now want to think about how we deal with them practically. So we're going to move to a discussion, as I say, in a panel format, which at the very least gives you all a chance to analyse the backgrounds to everyone's Zoom setups, even if you don't want to listen to the answers to the questions. So everyone's now online, and what we wanted to kick off with was I think a bit about more the question of trustee neutrality, which Clare touched on in her talk and others have mentioned. It is one of those issues which frequently exercises trustees. They feel that the right thing to do is to be neutral, but in reality they've often, as Clare said, either talking to the settler who set up the trust and that's the person getting divorced, or the other common situation is where you have beneficiaries are both of the spouses, one because they're a family member and the other by virtue of them being a spouse. In those situations, one can see that trustee neutrality is difficult because the trustee's natural alignment is preserving the value of the trust fund, doing right by the family of the wealth generator, and naturally the trustee will, because they're only human, think, well, if there's a divorcing spouse who's not going to be part of the beneficial class in 2 months or a year's time, how can we really be neutral between them? Isn't it more a question of impartiality? And how does that play out in practice? So I want to ask the panelists, is trustee neutrality really the right way of looking at these things? Are we more talking about trustee impartiality, and how does that play out in practice? Can it ever be, is it going to be the case that you'd say it was right for trustees in practice to have to favour one spouse over another, albeit doing so objectively, taking into account all of the relevant factors that they have to? I'll throw that open first to the family lawyers, to Alex and Mark, for their views before going around the panel.
I think it depends if the husband and wife are both beneficiaries, and even if you have a situation where the husband is a beneficiary, the children may be, and the children's interests, of course, may be different. They may want their mother to receive money directly or indirectly from the trust. But yes, if husband and wife are both beneficiaries, then the trustees do need to be impartial. Otherwise, there could be severe criticism, and there may be trust law remedies which could be pursued by either spouse. But I think, as Alex said, obviously, if one spouse is seeking a variation, then the trust assets are under attack, and the trust is under attack.
I mean, one point I would make is that if you come from the person who often provide the money in the trust, you start off with an inbuilt assumption that the trustees are going to be on your side, and you've got to rid yourself of that assumption, because it can lead to problems. So Bajul says that you can just be writing to the trustees and expecting there to be common interest privilege, and you've just got to just take a step back and think, actually, where is everyone's interest lies? I remember doing cases when I was acting for Mr. Mubarak. I was assuming that in the world we had one person who was on our side, and that was the trustees, and I was rudely awakened when they sort of said, no, we hate you like everyone else. So it's just you can't assume that the trustees are going to be on your side if the money comes from you.
That's helpful. And Alina and Bajul, just from that Chancery trustee perspective, how do you see that duty of neutrality kind of playing out in practice?
I think the main points have been highlighted, that in a sense although the litigation lawyers may often talk about neutrality, the correct view, I think, from the point of view of the trustee, is to look at each particular issue or each particular dispute that comes up, and for the trustee to work out for itself where its interest lies. And in some ways, impartiality may be the right response, but then there are other occasions where actually the trustee has to take active steps. So variation is a classic example where the trustee may well want to say defend the proceedings as they're happening, but it's not confined to those. You have to look at the particular circumstances. And of course, as has already been pointed out by Mark, the children who may be beneficiaries of the trust may well have a particular view as to how the trustee should be behaving, and that will condition their response.
That's really helpful. Claire, do you have anything just to add on that from the trustee?
Very little. I mean, the context I was speaking in was considering two beneficiaries and two spouses who were both beneficiaries. Frankly, I think I just reached for the wrong word. In that case, I think generally it would be impartiality that we would be looking for. But then, as I said sort of at the outset, I don't think you can rewrite history. Probably the trust files will show that there will be more communication with one beneficiary than the other. So there's going to be, I think, from the outset, a little bit of an unbalance, but hopefully, in that communication, it was also sort of the trustee was keeping the trust structure, administering it with integrity, thinking of all the beneficiaries. And I think that's really the key point, that, the long-standing administration of the trust needs to reflect that the trustees have the other beneficiaries in mind. We have said in non-contentious situations, you may be considered as the principal beneficiary, but you're not the only beneficiary. And I think that needs to come through. So that's all I have to say.
Absolutely. Thank you very much, Claire. I suppose if it's difficult for a trustee to achieve neutrality or impartiality or however we phrase it in a divorce situation, it's nigh on impossible for the divorcing spouses to achieve it. Perhaps this is another one for the family lawyers, for Mark and Alex, but what does a family lawyer, or a family court indeed, make of a cagey, uncommunicative, unhelpful spouse? Is he or she music to a family lawyer's ears?
When you act for the person where the money comes from, then you almost inevitably, in one of the first meetings, get the answers, well, it's not my money, it's a trust asset, which is odd because they generally want the trustees to do whatever they want anyway, but they try and sort of hide behind the trust when it comes to that. And quite often they will say, I don't really know very much about exactly how much it is. They may try and put in the trust section is, I'm a beneficiary of a trust and I don't know how much it's worth. And you have to sit on them, because that is going to go down like a lead balloon to the court. You've got to say, right, you've got to go as much as we can without triggering other issues, but you've got to be reasonably comprehensive, because once you get labelled as the person who's hiding the money, and you lose the ear of the judge, and then everything goes downhill. So you've got to be very, very careful.
Yeah, and I suppose it goes to Claire's point, doesn't it? Trustees can't rewrite history, nor can the spouse.
On that point, that it's quite instructive on this, that you can't rewrite history. If, for example, the trustees and the divorcing spouses have essentially ignored the complex structuring and treated the underlying assets as underlying assets of the spouses, it's hardly surprising that the court is going to take pretty much the same stance.
Yeah.
And if at that later stage, the husband then starts saying, well, there's this now complex structure and, trustees own this and there's these offshore companies, etc., it isn't really going to wash with the courts.
All I can think of is the Pugachev Angora cat. I mean, it wasn't Pugachev's, obviously, but Pugachev,
Yes.
being one of the trust case sort of James Bond baddie figures. Although my legal director did correct me, then I tried to use that analogy, that Blofeld's cat was Persian. But anyway, yeah, the analogy holds of the trustee being small and cuddly and sleepy when times are good, and then when the storm is on the horizon, something about eyes blazing and teeth all over the place. But yeah,
Very relevant.
we're probably off point by this stage.
I think very much on point. Cat analogy is always welcome. I think.
Haven't we had any cats and dogs in the court? Usually happens. And children.
and it is absolutely the case, isn't it, that the trustee suddenly has to change mode from having been a often sort of cuddly, helpful trustee suddenly to being much spikier and having to think about things which ordinarily it wouldn't have to think about. One of the issues, the problem of submitting to the jurisdiction, the desire sometimes to be helpful, but then also thinking, well, we don't want to end up being forcibly bound by court orders. I wonder, Bajul, whether you might talk a little bit about that first, and the dangers of submission to the jurisdiction and how trustees can avoid that.
Yes, so the main danger for the trustee of submitting to the jurisdiction of the divorcing court, is that any order that's then made by the divorcing court will bind it. And when it comes to the enforcement stage, the trustee will not really be able to rely on any legislation, any firewall legislation in its trust jurisdiction to be able to say that the order is not binding on me, because it'll have submitted and the order will be binding. So the trustee's actions on whether or not to submit has profound consequences further down the line. And that is why that is often one of the first and most important things, as Clare mentioned, that trustees will need to think about in the context of their BEDO applications. And it starts to become quite a difficult question. So for example, to what extent can the trustee provide information without submitting to the jurisdiction? To what extent can the trustee participate in the FDR without submitting to the jurisdiction? Now, trustees will often say, I'm submitting this information, or I'm participating in this FDR without prejudice to my contention that I'm not bound by the orders of this court and I'm not submitting. What remains untested is whether that reservation actually works in England. And then it becomes tricky. What happens if the FDR is successful and orders have to be made consequent on that? Do you have dispositive orders against the trustee, which then bind the trustee if it has reserved its position on the question of submission? Now, these are actually quite difficult questions that I think have to be tailored to the particular circumstances you have. But from the trustee's perspective, the first question I would have thought always is to consider very, very carefully what steps you can or should take and what you shouldn't take.
Yeah, and I think just following on from what Bajul said, on the one hand, it seems very sensible to get involved in, for example, without prejudice roundtable discussions or a private FDR, but it remains untested whether, if you reserve your position still, whether that really counts, or whether participating in those types of discussions, even with those reservations and with that prejudice sort of moniker, whether that would be enough.
I advised in a case where one of the trustee directors unwisely decided to come to court to give evidence at trial, and his evidence was so dreadful and conflicting with the documentary evidence that the case was settled outside court. And then there was a fight with the other trustee directors as to whether that director on his own had the authority to enter into an agreement, and was that enforceable, and that led to several more years of litigation. So I think trustees participating need very careful thought and presumably, ideally, blessing from their local court.
I just have a small thought there in terms of trustees participating. I mean, all those warnings are definitely heeded from a trustee's position. But I mean, just think for a moment about the likelihood that a lot of the information that a trustee would bring with them, or the information they would be asked to disclose, is quite probably in the court's jurisdiction anyway. I mean, you know, how many settlors don't keep a copy of the trust deed? How many settlors don't keep a copy of their letter of wishes? How many trustees don't send financial statements? I mean, there's going to be probably a lot in the files of your principal beneficiaries or settlors anyway. Is that going to be a factor?
Quite often you find that the client says they don't have them, and whether that's the case or not. If you are an ultra high net worth individual, you might assume that your advisors, and you probably think a trustee is one of your advisors, even though you're wrong, keep all your papers for you. So quite often they say, I don't have it, ask the trustee, because they have a relationship with the trustee prior to the divorce happening, which has to be readjusted, because you've got to say, well, and quite often what you have to say is you have to look at the trust structure and say, well, actually, you've got some people here who have got difficult positions. They might be directors of underlying companies, but are also trustees and your advisor, and now he's wearing lots of hats. Now, can we get rid of some of those hats, because you're going to cause problems? So I mean, I think that's quite a difficult thing for the advisors in the situation. I mean, I think on the participation point that it really depends from fact to fact. I'm involved in a case at the moment whereby the trustees have been involved from the start, and actually I had to dip out because I hadn't got funding, but they were sitting on all the money, so they were the only ones going to court with my client in person. And that's because all the money was in this country. There was a trust that wasn't in this country, but it wasn't far offshore, and sort of they knew they hadn't got a leg to stand on in enforcement. And so they just sort of thought, well, I'm going to participate and just try and help the court. And actually they've become sort of a neutral, impartial party, and we're both clients are fighting them at the moment because they want to keep the money in trust, and everyone's saying, no, we don't want the money in trust. So it's rather an odd situation, but it depends from case to case.
Yeah, and actually, Bajul's point that you're probably going to want to have directions at that point if you're a trustee as to how to participate. It raises another interesting point that I think, Claire, you mentioned in your introduction, which is how do we deal with that very real practical obstacle that trustees might find their application for directions in their home jurisdiction doesn't keep pace with the divorce proceedings themselves, and it sort of leaves the trustee in a position where it does not have directions but is being required to do something.
Okay, so my efforts to bounce that into Bajul's court have clearly fallen flat. Okay, so I'm going to have to tackle this. Yeah, it's uncomfortable. So, I mean, clearly we would be getting advice. And I mean, going back to the fundamental trustee duties, I mean, if the trust law has confidentiality provisions that means we would be in breach of trust with bowling on, then, you know, I don't think there's much we can do to be helpful. But I think generally speaking, we would try and be helpful. So with some advice and some pretty good grounding reasons as to why disclosure is in the interest of the wider beneficiaries, I think we would probably, you know, have to bowl on in those cases. Yeah, but it's uncomfortable.
Yes, and lots of the themes that we've been talking about have being the trustee trying to engage, but also work out firstly how much information it should share about how it's been dealing with things already, and then working out whether it should change anything going forward. I wonder, we need to look at both of those in a bit more detail. I wonder just on the question of how far you change things going forward, and this feeds into a question that someone has asked on one of the Q&As. If you've got a situation where you've been historically making distributions, how far should a trustee go in adjusting those distributions, and how credible is that likely to be for the family division when it sees what the trustee's done? If the trustee says, actually, we're going to have to stop now, and we mean it, do you think that is something a trustee can credibly do, and is it going to be helpful for the question of the resource argument? Mark and Alex, I think that's probably one for you.
I don't think it's likely to be credible. If there's been a long pattern of distributions of a certain amount, then it's the pattern that really matters. Now, maybe there's a very good reason why the distributions have suddenly stopped or been reduced because of the divorce, but most family judges are very suspicious, and if you've had years and years of distributions, it's very difficult to get away from that.
And it leads you to the classic problem, which is interim maintenance. And most family lawyers have been in the position where you advise, someone says, well, the money tap stopped during the divorce proceedings, and that leads to an interim application for maintenance, and you get an order against your client, and suddenly the money tap turns on again, and you sort of lost credibility, because and so it ends up with very difficult situations. It can do. You've got to have a very good reason why it stopped.
So if that stops you, I think that's a helpful answer on that point. I think probably then it's worth asking Bajul and Alina whether there's anything else creative that trustees can do that might help them, and that you want us to think about.
Much would depend on the particular history of the trust. But for example, in the noughties and in the early part of the previous decade, quite a lot of legislation went through which made it tax inefficient for non-doms to remain beneficiaries of various trusts if they were living here. And they were often excluded from the trusts. Now, sometimes in a divorce situation, the attacking spouse might well take the view that all of the exclusions were quite suspicious. The trustees may well want to take proactive steps to work out, for example, whether those exclusions are valid or not. And they might want to do that from their own home court, so that at least they know who their class of beneficiaries are. That's one that I think we're seeing as a if you like, a sort of a consequence of some of the tax legislation that went through in the last 10, 15 years. There are other types of situations that you'd have to look at carefully, but often the family division scrutiny will look at this quite carefully to see whether what's being sought is some form of anti-avoidance against the orders of that division. Sorry, Alina, I interrupted you.
No, I was also just going to mention another potential active step, although we would never advise that a trustee would take it, and that's the flee clause, which is really a clause in a trust document where on specific sort of trigger events, the trustees are entitled to transfer the trusteeship and administration to some other potentially less favourable jurisdiction. But although that's a creative step, it's not one we would advise a trustee to take.
Quite fun to have a go though. So that's really helpful. Thank you for that. Before we move on just to talk about anything else, there was just one question, freestanding question, which had come in, which was actually on cost and thinking, sort of flipping the tables from what the trustee's thinking and the risk for the trustee to the risk for beneficiaries of trusts and divorcing spouses who are seeking to join them, which is the question of costs. And someone has asked what, as the trustee agonises about what to do with a potential joinder application, what is the risk on costs for the divorcing spouse who applies to join the trustees and may end up being unsuccessful? Unless anyone were to think that never happens. It happened to me recently, acting for a trustee who was geared up with a directions application all going, thinking that they were about to be joined, and the joined application was, we understand, roundly rejected. Alex, Mark, would you think, are there any cost consequences which are likely to follow for a spouse in that situation who's failed to join? Yes,
I mean, it's a good point, because particularly on complex structures where you have a trust with lots of underlying companies, the blanket, I'm going to join them all, could be left. If you're cunning on the other side, you sit down and you think, well, these ones really aren't part of this at all, these companies, and you apply to de-join those. And once you've done that, you will get a costs order against you. Now, it's likely you're going to say that not to be enforced till the end of the proceedings, so you're probably okay. But you don't want to lose interim applications. It sets the wrong principle. It gets the moral high ground to the other side, and you just don't want to do it. So you've got to be very careful about choosing who you want to join, and you don't do a blanket application.
That's very helpful, thank you. I'm conscious that we have overstayed our welcome by a few minutes, so we probably should start wrapping things up there. I know that I'm conscious that there are some questions that haven't been answered, and we apologise for that. One thing that someone has raised is the question of Dawson Damer and DPAs and SARs, and I think that sounds like a whole separate seminar topic in and of itself. Well, with hopefully the new GDPR regulations limit the extent to which they might be subject to such requests might be used in future. So if I can just offer some closing thoughts before we all let you go to hopefully your lunches in the sun with a glass of rosé. It seems to us, above all else, is the issue of communication is key. Communication with your beneficiaries before all this happens. Communication with the key family members to make sure the trustee is set up to deal with these things. And then once the divorce comes on the horizon, being clear with beneficiaries about what the trustee can and cannot do, what it can't say, and then taking clear advice from lawyers, both on the contentious and family side, about how the trustee should then interact with the proceedings and communicate with the court if helpful. That seems, from our point of view, from what we've heard and what I've heard, to be the absolute key here. I am very grateful to all of the panelists for taking the time to come on and share their views and experience and expertise. The final thing to say is that we have been asked whether we're going to circulate any notes of the cases that have been discussed, and we certainly can provide everyone with just a quick rundown of some of the key cases that were covered, just so people have a note as to what we're being referred to, and then can read those cases as well for themselves afterwards. But without further ado, it's a goodbye from us, and we hope to see you all again soon.